Mr. Chaffetz for 5 minutes.
Thank you, Mr. Chairman, and to the Director, thank you. You've made yourself regularly available to this committee, and as a member, it's very helpful, and we appreciate it and appreciate your service. I want to talk a little bit about geolocation, metadata, and specifically the Jones case, which is a Supreme Court ruling where they ruled 9-0 that a GPS device placed on a vehicle for an extended period of time was an unreasonable search. Geolocation is broadly defined as using a GPS device or triangulation so that you can tell the specific whereabouts of where a particular phone is. Could you help me define what metadata is? Because what we've seen in the news is that the metadata category is the simple telephone number, where they're calling, and how long they're calling. Can you help me define what else is in the so-called metadata category?
Well, in the case of emails, it would probably be header information. I think people would consider
what about specific
addressing information, but not the subject line, for instance. That would not be metadata. In terms of the telephone, it would be that which you articulated principally.
Would it include geolocation information?
That's a question I'd have to get back to you on. I had not thought about that.
We submitted in advance our questions that we were going to ask here today, in part so I could have a candid dialogue with you. We were very good at providing the questions that I was going to ask.
No,
with all due respect, sir, you're the director of the FBI. You've been there for 12 years. You had to have think post-Jones, what are the implications of the Jones case? What is geolocation and how does it apply?
Absolutely. I mean, we have been, after the Jones case, we have taken in, and the Jones case can be applied to a number of ways that we utilize geolocation. In each of these different ways, we have taken the most conservative approach because you don't know what is going to be the progeny of Jones. On the particular question of whether or not geolocation is metadata off the top, well, I shouldn't do it off the top of my head. I have to make certain that I look at that one.
Is there a database of geolocation information that is warehoused by our federal government?
Not that I'm aware of.
Post-Jones, there has been guidance given by the Department of Justice to the FBI. I would love to see that information and share that. I've seen 2 unclassified documents that were through a Freedom of Information Act. Is that something that you can share with this committee?
I'd have to look at that. But if it's unclassified, internal, then I'd have to look at that.
All right. I guess what I have a problem is this phone right here, the federal government has no problem following this phone, who I call. If I call my 12-year-old daughter, the telephone number I called her on, how long I had. But the geolocation is something that I have a bill that I've sponsored that would record, that really basically categorizes geolocation as content as opposed to metadata. So if you're going to follow what this telephone number is, where it is that or is that not content?
Yeah, I think that's I'll tell you, I think it's a very difficult question, and I'd want to think about it. It can be metadata, it can be content, and it may depend on the circumstances.
But is there a database that anybody knows of that
I do not know of a database that specifically is addressed to geolocation, apart from anything else, other investigative activity that is solely a geolocation database.
Post-Jones, does the FBI believe that there should be a lower or different standard for law enforcement to access geolocation information from smartphones or other mobile devices than the standard for attaching tracking devices to cars under Jones?
I have to get back to you on that. I apologize. I can see you gave the questions, and I did not get briefed on. It's my own fault for getting briefed on the question, so I'm better able to answer them.
I appreciate it, and Mr. Chairman, it's terribly disappointing to come to this point, talk about something that is in the headlines of every newscast. I gave the questions in advance.
And they noted that I would be asked on that, I might add. So it's my fault.
Your staff did some great work, I guess, but it's terribly frustrating, sir. You're the head of the FBI. You're the director of the FBI. This is not this is an important discussion and dialogue, and I know I won't get an answer, and that's
I
the
will be
frustration.
happy to meet with you after I've had a chance to review the questions you have and the answers that you need.
What would be a reasonable time frame for me to start to call foul and say, hey, where's this information? Okay, I appreciate it. Thank you, sir. Yield back.
Gentlewoman from Washington, Ms. Delbaney, for 5 minutes.
Thank you, Mr. Chair, and thank you, Mr. Director, for your service and for being with us here today. I happen to agree with those who believe that greater transparency and better data about the requests that government entities are making to Internet companies and providers will help inform the discussion that we're having about how to balance legitimate national security needs with privacy rights. I understand it was referred to a little bit earlier that Google sent a letter to you and Attorney General Holder earlier this week requesting that it be permitted to provide reports of the number of FISA national security requests it receives as well as their scope. And I wondered if you could share with us what your response is to that request.
I think that's being looked at by Justice at this point.
Okay. Then earlier this year, Google did work with the Department of Justice and the FBI to disclose in broad strokes the number of national security letters that Google receives. And did Google's disclosures of these numbers harm national security in any way?
Well, let me just hypothesize without answering particularly. If you had such figures out there, would not somebody who wanted to have secure communications maybe make some decisions as a result of that information as to what, what communications capability they use? So it's basically there are issues that need to be discussed in the course of deciding what needs to be declassified. I think most of us in the government would love to be able to disclose more because it would be more understandable to persons, but you have the conflicting values of trying to protect the country and trying to protect that information that enables us to continuously identify and to intercept the communications of terrorists in an effort to thwart attacks. That's the conflict.
Thank you. The committee is currently also considering reform of the Electronic Communications Privacy Act. And as you may know, the Senate Judiciary Committee recently reported reform legislation out of committee. Members on both sides of the aisle seem to agree that we failed to modernize our law to align with reasonable expectations of privacy, especially in the digital age. For routine criminal investigations, I believe law enforcement should use the same standard to search your inbox that they do to search files and letters in your home. But our current outdated law allows police to provide only a subpoena issued without a judge's approval to force service providers to turn over emails that have been opened or are more than 6 months old. The committee is currently considering legislation that would require government entities to obtain a warrant before having access to stored content. And I'm pleased that the Department of Justice and Attorney General Holder recently acknowledged that reform to the Electronic Communications Privacy Act has failed to keep up with the development of technology. And I wanted to know if you agree that it's time to reform these laws to include a warrant standard for stored content.
Well, I would agree that it's time to relook at these laws given the communications in terms of what the impact it would have on particular requirements of particular situations. I would wait to see what kind of legislation is proposed.
Do you have a proposal of what kind right now? If I have a physical letter, a piece of paper in my home, you need a warrant. If I have an online piece of communication, it doesn't necessarily have the same standard.
We'd be pleased to get back to you either by regular letter or by email.
And in terms of broader reform, in terms of keeping up, do you have recommendations on other reforms you think that we need to look at? Because the way that folks have communicate now is very different than the past. You talked about chat and other forms. Clearly, our laws have not kept up with the changes in technology. And do you have an opinion or ideas of how you would like to see legislation formed there?
Yeah, we'll get back to you on that with whatever ideas we have. I do think there needs to be reform. There is always an impetus to increase the standards to get particular documents. But it should be done, in my mind, dependent on the attributes of privacy that are necessary for a particular means of communication or a particular piece of data relating to communications. If you raise the standard too high, we then do not get the basic information that can identify terrorists to the point where then we can take the additional investigative steps. Identify the subscriber. Once we've identified the subscriber, identify others in that network. If we, as a result of that predicated level investigation, find that they are involved in terrorism, then getting a wiretap. We tend to confuse that which is covered by the Fourth Amendment and that which is not covered by the Fourth Amendment. And so as one drafts the legislation, my belief is that ought to be kept in mind.
Thank you, and thank you, Mr. Chair. I yield back.
Chair thanks the gentlewoman and recognizes the gentleman from Utah.